deal with. And that is this confusion, my lord, about occupying a field. What is the consequence of that declaration in section 2? Now for this, my lord, my learned friends have relied upon Hingir Rampur and MA2 Lock.
And forum.
And my lord?
My judgment in forum.
Yes, yes, the lordship's judgment. Now, my lord, here there are two words which, my lord, has sometimes gone into some difficulty even in judgments of this court. Repugnancy, number 1, and denudation, number 2. It has created problems because the words themselves can be used in different senses. Well, the correct position is specified in Hex judgment, which Mr. Dwivedi mentioned in the morning. And because, my lord, there were some contradictory statements in some 2-judge bench, 3-judge bench judgments, in innovative, your lordships, my lord, again affirmed Hex, quoted the entire passage from Hex, my lord. That is the easiest to understand passage as far as, my lord, the relationships are concerned. And the difference is, my lord, the word repugnancy should correctly be used only for the concurrent list, list 3. 2 legislations in list 3, a central legislation and a state legislation in list 3. Repugnance.
It is Article 254.
Repugnance is not to be used when there is an apparent conflict between legislation in list 1 vis-a-vis legislation in list 2.
The Picton substance doctrine.
Precisely.
Incidental and ancillary.
Incidental, ancillary. All those, my lord, are how you will apply. What is the principle, my lord? The principle is that if it is in its correct interpretation, Picton substance, etc., really in list 1, then list 2, you cannot legislate at all. And similarly, if in Picton substance it is in list 2, you cannot legislate. So this is different from repugnance, because in repugnance, till somebody legislates, the other legislation is valid. Now, my lord, what is denudation then? Denudation is when you remove an article, you remove an entry or some part of an entry from one list to another. So list 2 says in entry 23, regulation of mines and minerals subject to the powers exercised by the Parliament in under list under entry 53 or something. 54 and entry 54. Now, when you do that, you remove something from list 2 and take it to list 1. Then also there is no question of repugnancy. Then there is a question of denudation.
It's in the nature of an abstraction.
It is an abstraction.
One entry is made subject to another entry.
Yes.
So that that's the first entry is in that sense subordinate to the earlier entry.
Yes.
To the later entry.
If you give the declaration.
If you issue a declaration.
If you issue declaration. Now, Hingir Rampur and Tulok are both cases of
entry 23.
They are all below entry 23 vis-a-vis 54. So they were cases of denudation because there was list 1 and list 2 involved. No list 3 business. There was a separate argument relating to list 3.
Yes.
In that context, the court said, the lordship said in both those 2 matters, that it depends upon the extent taken away and put into list 1. Because that's the language also, to the extent.
Yes.
How much is carved out?
How much is taken away, how much is staying back?
Denuded.
Denuded. What is taken away is denuded. Now, in that context, your lordship said in both the two judgments that the field being covered by both is regulation and development of mines and minerals. Sorry, my lord, control, I think. Control and conservation and development of minerals. So what it found was, my lord, that both, when you make that declaration, you take away the entirety of it. The regulation, the conservation and development of minerals, which was in list 2, the entirety of it is taken and put into list 1 because the declaration is like that. Having said that, in both the two judgments, they said that since the fields are the same, therefore nothing remains. Mere enactment is enough. The very existence of the law is enough.
That is my lord.
Give us only 1 second to do the electronic housekeeping work, as we call it.
Now, my lord, the difference between Hingir Rampur and Tulok was very simple. Hingir Rampur dealt with a legislation where the declaration was a pre-constitutional declaration by the central government, whereas the state legislation came in after independence. So the result was, even though they found that the entire field has been taken away, they said that this declaration is invalid because it cannot cover a post-constitutional legislation. The declaration was under a pre-constitutional law. The power was with the central government. Now it is the state law has come. You cannot declare. In those circumstances, you could not declare. Therefore, Hingir Rampur failed. It remained with the state. Then, my lord, 1957 legislation, MMDR Act came in, Minerals and Mines and Minerals Development and Regulation Act came in. This time, my lord, it said Parliament. And now that it said Parliament, when the matter went back to court, they said that from 1958 onwards, the field has got denuded completely. So you're now out. But in doing so, it said we do not even have to decide the question as to which part of the field has got denuded, because it has already been held in Hingir Rampur that the entirety of the field has got denuded. This is the distinction, my lord, between Tulok and Hingir Rampur. The same state law won the first time, lost the second time, state of Orissa.
This is the argument.
Now, therefore, it is not enough that there is legislation. Mere existence of legislation is not enough. You have to see what is the field taken away. Now, my lord, there is one passage here, my lord, which clarifies the situation so much that I am just tempted to read. As far as this case is concerned, I know, I've got it written. Volume 5F, page 396, my lord, is Hingir Rampur. Volume 5F, page 396. Yes. The PDF page, my lord, is 409 and the paragraph is 24. And after reading entry 23 with entry 54 of list 1, it says that the effect of reading the two entries together is clear. The jurisdiction of the state legislature under entry 23 is subject to the limitation imposed by the latter part of the said entry. If Parliament by its law has declared that regulation and development of mines should be in public interest, be under the control of the Union, to the extent of such declaration, the jurisdiction of the state legislature is excluded. In other words, if a central act has been passed which contains a declaration by Parliament as required by entry 54, and if the declaration covers the field occupied by the impugned act. So there are two conditions. One is there must be a declaration, and the other is that the declaration must cover the field occupied by the impugned act. The impugned act would be ultra vires, not because of any repugnance between the two statutes, but because the state legislature had no jurisdiction to pass the law. It's gone, denuded. You don't have power under list 2. Not because of repugnance, because that would take us to the concurrent list. The limitation imposed by the latter part of entry 23 is a limitation on legislative competence of the state legislature. This position is not in dispute. And then it says, my lord, that it satisfies that test. That second test, first, of course, there was a declaration of a different kind. Secondly, it satisfied the test that the field occupied, the said declaration covered the field occupied by the impugned act. Then it found, my lord, that the declaration was not a valid declaration. So the state succeeded. In Tulloch, which is, my lord, volume 5B,
5D.
5B, B for not Mumbai, my lord. Page 108 is where it starts. And I'll show you, lordship, para only. I'll read out para 5 only. Para 5? No, I don't think 5 is necessary. My lord, it says basically, my lord, sorry, my lord, I'll put the paragraph number. It says that it has already been decided in Hingir Rampur that the field was the same.
Yes.
And now that we have a proper declaration, now it is taken out of the jurisdiction of the court, of the state. In fact, since it is an existing legislation, they say now it has got eclipsed or it has, that is paragraph 14. My lord.
Para 14 at page 5B, right?
Yes, 5B, but the PDF page is 124. So I'm just reading the first sentence. We consider that this submission in relation to the act before us is without force, besides being based on a misapprehension of the true position. In the first place, the point is concluded by the earlier decision in Hingir Rampur. Therefore, it follows it to that extent. Now, my lord, if I have to apply it to this case, entry 52, there is a declaration under entry 52 here. If Tikaramji is correct, then entry 52, the field is not the same.
So, interestingly, in this para 14 that you were reading out from Tulloch,
yes,
they applied the doctrine of occupied field here also. They were really dealing with entry 23 and 54.
Yes.
Bottom of that para.
Yes, yes.
Where they say the test of two legislations containing contradictory provisions is not, however, the only criterion of
the only criteria of repugnancy. For if a competent legislature with a superior efficacy expressly or impliedly evinces by its legislation an intention to cover the whole field, the enactment of the other legislature, whether passed before or after, would be overborne by the grounds of repugnance. My lord, it says so, but my lord, it is clear that this is, that's why, my lord, I've given your lordship the passages from Hext and Innovative, where they have clearly said that you cannot have repugnance. You can have repugnance, my lord, as the word stands, my lord, it does cover the field, but it's not repugnance. In technical language, it is not repugnance as far as constitutional law is concerned, it is really, my lord, a case of denudation. Then only, my lord, this mere existence of the law is enough. It covers the field. Now you can't touch it. Because what has happened? By that declaration, you have taken something out from here and put it there. Now, what are we arguing, my lord? We are arguing that because of Tikaramji, raw materials are outside the scope of industry. So the declaration does not cover the field. The field is not the same. So the second test fails, my lord. The field not being the same. You cannot say that mere existence of a legislation is enough. Now, only one more thing and I'm done with it. In fact, Hindi Rampur has another passage. I think it will complicate things too much if I go into it now. This entry 52 was also pressed into service there. When the court did not agree to 54, they pressed into, in the argument, they went to entry 52. There, it was rejected on the ground that the Industrial Development and Regulation Act is not for regulation. Having analyzed the Act, it said it would thus be seen that the object of the IDR Act is to regulate the scheduled industry with a view to improvement and development of the service that they may render to the society and thus assist the solution of the larger problem of national economy. It is difficult to hold that the field covered by the declaration made by Section 2 of this Act, considered in the light of its several provisions, is the same as the field covered by the impugned Act. That being so, it cannot be said entry 52, read with...
Mr. Jadip, just one last point.
Yes.
What if, just since the whole matter is really at large before us.
Yes.
What if we come to the conclusion that Tikaramji is holding that the raw material is outside the fold of industry?
Yes.
Is perhaps not correct. If it's a controlled industry, the product goes to entry 33.
Yes.
Otherwise, it would go to 27.
Right.
Otherwise, in the case of a controlled industry, it goes to 33, which Tikaramji says.
Yes.
On raw material, suppose we come to the conclusion that the raw material will also fall within the scope of industry.
Yes, the entire raw material. But
then what happens? No,
the entire raw material then begs the question that if it is going to be used for IMFL, then it can't come in because of entry 8. So there then has to be a system.
The point of removal then.
On the point of removal, but there are various regulatory measures which are taken which are specific to the process of manufacturing. Theoretically, there is no difficulty in saying that if you say that raw material is included, then raw material for the manufacture of denatured spirit will be covered by the word industry. And it would be open to the center to parliament to legislate in relation to the raw material for the manufacture of denatured spirit. I think, however, Miller, I have a caveat. One caveat, my lord, your lordship will keep it in mind that then production, supply and distribution will be of a notified product. And if it is of a notified product, my lord, then it will be entry 33 concurrent list. So if the center does not in fact notify, and we are arguing that actual notification is required, and I'll just, my lord, make one submission relating to that. Since we are arguing that actual notification is required, till such time as actual notification is made, state will be able to regulate.
Yes.
Now, on this aspect, my lord, of now let us think of repugnancy, because now your lordship has put that question to me, and I question will arise. Now, my learned friends are interested in saying that even if I do not legislate, even then it is covered.
Forbearance.
Forbearance. Then what will happen, my lord? In a concurrent list item, every non-legislation will also become covering the field.
Then what is occupied field?
It is legislation not acting on that legislation.
No, this is
That's
not
the-
acting on the legislation. This is delegated
a
legislation. Notified, my lord, means delegated legislation. My lord, a submission was made in the morning that it is in the nature of an executive order. No, it's a delegated legislation. You are notified.
Occupied field. That's the-
Which is why, my lord, Justice Jeevan Reddy in Bihar Distillery said that we are also taking into consideration the fact that there is no actual notification under 18G. He took that into consideration. And
Ratna said, what is the relevant, how do you explain the doctrine of occupied field? Because we are in the area of entry 33.
now we have come to repugnancy. The occupied field will mean not that there is merely a law, that it must be that there is a delegated legislation applying the law. The law must be complete. My lord, your lordship has already heard, my lord, it is occupied. That's why, my lord, it is constantly said. And my lord, this is important because
That was the line which Belsun Sugar took.
that's right, my lord. And this is important because when we come to the concurrent list, the state is also having the power to legislate. It is only that if the center legislates on the same, then it will get occupied and it will cease to have effect. Different, my lord, from a conflict between list 1 and list 2, where the state never had the power.
And Parliament, according to you, we'll consider it. Parliament, according to you, while legislating, intended that the legislation by itself will not be enough, but there has to be a notification by
There
the
has to be a
central,
notification.
by the central government.
Lordship.
So in other words, if there is no notification at all, then Parliament did not intend to oust the power of this.
And it has not in fact occupied the field. It can easily occupy, my lord. Tomorrow they can do it. That's why, my lord, this argument, my lord, has limited usefulness.
Only thing that is
Yes.
a little conceptually, can you
Yes.
say that the doctrine of an occupied field is dependent on the exercise of power by the delegate?
Yes, my lord. I'm saying so, my lord, because otherwise it has not occupied the field. It is to occupy the field by issuing a notification.
The notification is not necessary for bringing into force the law.
So therefore, my lord, that's why I
Case
make,
where you have not brought the law into force.
so my lord, that's what I'm saying.
The notification is only for implementing the provisions.
It's not for implementing.
That's the area where, I was
No,
a
no.
little,
Just
the
consider-
data, I was not on all fours. I mean,
Very well,
if you'd
very well,
like to
Milord.
just sort of.
I'll just make
repeat
one
2 minutes
submission.
And then we can call.
I'll just make one submission and leave it at that. Your lordships may consider. The question is this, my lord, that the legislation says that only if we notify this product, we will control. If we do not notify, we will not control the product. Why should the state, in a concurrent list position, lose its power in a my lord, denudation?
Yes, on the other hand.
So therefore, my lord, I say that forbearance, my lord, is not to be applied in the case of a concurrent list subject.
Unless there is a delegated legislation exercise, only because the law is there, the law does not occupy the field to cause difficulty for the state.
To cause repugnancy. Yes. If
For
it is a
repugnancy,
concurrent list.
For repugnancy, it has to be an occupied.
Yes.
And you are saying that it's not occupied.
Till the delegated
Till the
legislation
delegated
has actually brought it into.
exercise is undertaken.
It's very simple, my lord. They can today say that I am now notifying. So far they haven't, that's a different thing. It's in their hands. So, my lord, those are my submissions. My lord, one more thing. Lord, we haven't spoken about. हो गया, हो गया.
Something not on the merits of the case.
Regulatory measures. My lord, one thing which one thing I have not, my lord, submitted on is entry 6 of the list 2, which is on public health. Now, the reason I have not made a submission is that if in fact there is a legislation by the state which seeks to rely on entry 6, then my lord, we will have to justify that in a court of law. So it perhaps, my lord, it's not necessary for a comment by your lordship, but only thing is your lordship may keep that in mind, that when there is a public health my lord, reason, then the state again has power to legislate, and that power is not subject to anything at all. That's entry 6, list 2. I just wanted to mention.
Thank you, Mr. Gupta. Thank you, Jagdish.
Deeply obliged.
Yes, Mr. Giri.
Please, your lordships.
Your lordships leave the lord.
Yeah, no, you can safely leave. Thank you.
May it please your lordships. Lord, if your lordships recall, Lord, in my first submissions also, Lord, I was submitting that entry 8 would cover every kind of alcohol other than denatured spirit. There was a reason to do that. Firstly, my lord, as your lordships had taken note of, the entry starts with intoxicating liquor. Denatured spirit, which is an end product, and therefore, my lord, it could be synonymous with alcohol being used for industrial purposes, which is industrial alcohol, would not come within the purview of entry 8, my lord, because entry 8 deals with intoxicating liquor. And we have no material, my lord, to even assume on a hypothetical basis that denatured spirit could be a raw material for potable alcohol at a later point of time. Entry 8, my lord, is completely exhaustive of intoxicating liquor, my lord, coming into being, and even after that. My lord, the words manufacture and production coming in entry 8 cannot be treated as a repetition, nor can the word, my lord, production be treated as a surplusage. My lord, manufacture generally relatable to the end product, and production could be related to the products which come in between, intermediate products. Post-production and manufacture, possession, transport, purchase, and sale of intoxicating liquors. Every aspect, my lord, every aspect of manufacture or production or manufacture of an intoxicating liquor is covered by entry 8. Therefore, my lords, production of ENA, which could be treated as a stage prior to the stage at which Indian-made foreign liquor or a beverage, as the center would call it, is also covered, my lord, by entry 8. Starting from molasses, then to rectified spirit, and then to ENA, and then finally to Indian-made foreign liquor, my lord, which is what is done in the case of consumable alcohol, or what is treated as an intoxicating liquor, is covered by entry 8. My lord, the legislative competence of the state legislature, insofar as entry 8 is concerned, would therefore deal with every stage relating to the manufacture of an intoxicating liquor and even stages thereafter. Lord, we can conceive, my lord, of industries which manufacture only extra neutral alcohol and then sell it, my lord, to a bottling plant. There are many such industries.
Come again. What do you say?
There are industries, my lord, which only manufacture extra neutral alcohol, but don't take it to the next stage, my lord, of an Indian-made foreign liquor. They can sell it to any other unit. That is also covered by entry 8. There are industries, my lord, which procure molasses or malt, and then, my lord, come up to the stage of rectified spirit and then sell it to another unit, a distillery, which manufactures extra neutral alcohol. There are units, my lord, which deal only with bottling plants, purchase extra neutral alcohol, and then convert it into the different brands of liquor that we see in the market. But every aspect of it, my lord, would be covered by entry 8. That's why, my lord, the entry 8 deals not only with manufacture, but with production and every aspect of it, even subsequent to manufacture. Therefore, my lord, to say that I would stop with molasses, I cannot get into the stage of manufacture of Indian-made foreign liquor. I cannot get into the stage of manufacture of extra neutral alcohol, would be, my lord, to my lord, dissect entry 8 and then say that it will not deal with production, or it will deal with production only up to a limited extent and not beyond. So, my lord, the part of the production, my lord, of Indian-made foreign liquor, as they call it, beverage, my lord, I'm taking the path of least resistance. Of Indian-made foreign liquor would be the, my lord, the production of extra neutral alcohol or my lord, even rectified spirit, which comes beyond that. I'm just going by, my lord.
Previous stages are also covered.
Yes.
Lead up to production.
Correct. My lord, to do otherwise would be to say.
Will the same argument not apply to industry under entry 52?
That's, my lord, that's where, my lord, I would respectfully submit. Your lordships may come to that at a slightly later stage. I am saying that if entry 8, my lord, is comprehensive, it comprehends every stage, my lord, of manufacture of an intoxicating liquor. My lord, this is not to give up the argument that ENA is also an intoxicating liquor. My lord, that's why I submit.
Mary's first argument.
Yes, not denatured spirit. No, not denatured spirit.
Yeah.
I'm saying, my lord, that extra neutral alcohol is also an intoxicating liquor. And this is why, my lord, synthetics and chemicals has gone completely wrong. In saying that unless I'm in a position to consume it as it is, it cannot be treated as an intoxicating liquor. No. I'm saying, my lord, intoxicating liquor per se would be anything, my lord, which will give the effect of intoxication. It can be consumed without, my lord, without really.
In fact, the words that is to say,
Yes.
are words of expansion.
Expansion, it's always been.
Yes.
My lord, suppose your lordships are pleased to, just hypothetically, entry 8, intoxicating liquors. Leave it at that. This argument could have been raised even at that point of time, but it is not necessary. I don't have to go to that extent. I'm saying, my lord, that if your lordship say manufacture production means, my lord, of an intermediate product, and then manufacture is the final product. And therefore, my lord, every aspect of it, every aspect of, my lord, the process by which ultimately we get into the stage of manufacture of Indian-made foreign liquor would be covered by entry 8. My respectful submission is, under 245 or Article 245 or 246, in respect of any entry, my lord, which is contained in list 1, my lord, without even resorting to pith and substance argument. But that is in relation, my lord, to two competing legislations which come under list 3. For list 1, exclusive competence, my lord, to legislate on any aspect of coming under an entry under list 1 would be Parliament. Similarly, my lord, with regard to every aspect that comes under a specific entry in list 2, the legislative competence, my lord, is solely that of the state. Now, my lords, when you lordships go back to entry 52, would it be possible, my lord, for us to urge that your lordships construe the competence under entry 52 as also, my lord, to take in something which is completely covered by entry 8? Please don't come to entry 24 or 24 and I'm saying that for the purpose of anything which is wholly, comprehensively covered by an entry in list 2, one doesn't have to fall back on, well, it's the entry 24. Therefore, the competence of the Parliament to legislate, my lord, under entry 52 of list 1 cannot take in, my lord, legislating on any aspect which otherwise could be covered by entry 8. State does not have to fall back upon entry 24.
Why can't the reverse apply? Anything like fermentation industries is covered under entry 52.
Fermentation industry, my lord, it
But
is only.
how much of fermentation industry is covered is the question.
No, I'm saying, my lord, that fermentation industry, suppose, my lord, it takes in any aspect to the manufacture or production, my lord, of intoxicating liquor, then it is completely covered by entry 8. My lord, there is no question of supremacy of Parliament in this. The amendment of 2016, again, my lord, makes it clear, probably, that's what Mr. Balbir Singh, my lord, by learned friend says. But I'm saying that to construe, my lord, the scope of an entry, one cannot go into a legislation, my lord, which has been enacted under that. And therefore, my lord, I'm stopping short of it. Maybe they have done it right in 2016. But in my respectful submission, a declaration under entry 52 of list 1 cannot take in, my lord, anything which is exclusively covered by an entry, my lord, in list 2. You don't have to challenge the IDR Act, my lord. I'm only there before your lordships to, where your lordships can construe that this therefore will not cover anything under entry 8. But for all this, my lord, I'll have to still, my lord, convince your lordships that every aspect of it, every aspect of intoxicating liquor is covered by entry 8. If that is so, the exclusive legislative competence to legislate on those aspects of intoxicating liquor would lie with the state, in which case, my lord, in which case, consequently, the legislative competence of the center under entry 52 would not take in anything that is completely covered by entry 52. This is not a case of competing entries. This is not a case of competing entries under list 3. For that, my lord, I'll have to, the list 3, entry 33 will have to be looked into. I'm saying that the declaration under entry 52 will have to stop short of any aspect that is covered by a comprehensive entry in list 2. And consequently, my lords, the industry or industries which are mentioned in entry 24 aspect for this purpose will not take in some parts of IDR Act, my lord, could be traced to entry 33. And therefore, my lord, the argument on the question of repugnance, denudation, all comes in, my lord, when the legislation is treated as one under entry 33. Entry 33, my lord, would kick in only if there is a declaration by a legislation, my lord, under entry 52. My lord, in my respectful submission, one really does not have to go into that to find out whether, if your lordships find that entry 8 covers comprehensively every aspect of production, manufacture, among other things, of intoxicating liquor, then, my lord, it's hands off, insofar as the legislative competence of the parliament, even under entry 52, is concerned. They are in watertight compartments, my lord. In list 1, just as it applies to list 1, it, my lord, applies to list 2 also. And that is what your lordships have held, my lord, in several judgments. And that's, my lord, that's the cornerstone of a federal structure of the constitution also. There is not a question of, my lord, comparison of the legislation. It's a question, my lord, nor is it a question of challenge to, my lord, to the parliamentary legislation. Your lordships are construing IDR Act and whether, my lord, IDR Act could touch anything which is covered by entry 8 of list 2. And if your lordships are pleased to accept my submission, then, my lord, the question of IDR occupying the field, my lord, really need not be gone into, my lord. Why should it be gone into? Because that is gone into only for the purpose of entry 33, my lord, of list 3. That is why, my lord, the lordships will have to look into the question as to whether there is a denudation, whether there is a repugnancy, and whether, my lord, the conflict cannot otherwise be solved. Harmonious construction and things like that. My lord, two aspects on which, my lord, I have already made submissions. My lord, I am not taking your lordships to those. Para 74, my lord, synthetics and chemicals. And this is something which your lordships may kindly know. My lord, made an assumption that extra neutral alcohol is industrial alcohol. Lord, on what basis? My lord? With the utmost respect, my lord, I pose this question unto myself. There is nothing, there is no. That's why, my lord, I respectfully submitted that substitute extra neutral alcohol is found in paragraph 4 with denatured spirit, my lord. Everything else will fall into place. Denatured spirit would be industrial alcohol. Lord, Mr. Datar in his second chart also mentioned that denatured spirit is manufactured from extra neutral alcohol, add denaturants, and then you get industrial alcohol, which is denatured spirit. It's not an intermediate product. But extra neutral alcohol, my lord, is an intermediate product for the manufacture of potable liquor, and that is admitted. If entry 8 is, my lord, construed in such a manner as to deal with every aspect of production, including every aspect of manufacture of intoxicating liquor, including, my lord, what ultimately is the penultimate product which is necessary, my lord, in the stages, in the different stages of manufacture of Indian-made foreign liquor, that is extra neutral alcohol. Before that, rectified spirit. Before that, my lord, molasses. If the entry 8 therefore covers it, then obviously, my lord, it has to cover extra neutral alcohol. It will not cover denatured spirit, my lord, in my respectful submission, because that is not intoxicating liquor. My lord, one has to construe it, my lord, logically. My lord, a denatured spirit may also give an intoxication. Nobody takes it that way. It's fatal. Methylated spirit, my lord, in small quantity also results in the death. Therefore, denatured spirit would go out of it is my respectful submission.
The point still remains that, your argument on entry 8,
Yes.
that production would cover every anterior stage, including ENA,
Yes.
which is really a raw material in that sense in the manufacture of,
Correct.
would then run contrary to the logic of Tikaramji.
My lord, I really
That
don't.
part.
I really don't. My lord, Tikaramji has been argued, my lord, in.
All right, anyway, we'll. But your argument on this part has some compelling attraction to it. I mean, you've made a point. We'll reflect on it.
Lord, I really submit that this is not generated, my lord, from a quest for your lordships to affirm Tikaramji. This is, my lord, placed as
Of course, yes.
before your lordships.
Yes, of course.
Therefore, my lord, keep aside Tikaramji also, my lord. I would also respectfully submit that Tikaramji may be affirmed by your lordship. That's for the purpose of entry 33 of list 3, my lord. And that is how it has been gone into in Tikaramji also. But if your lordships are pleased to accept, my lord, and this is a submission, my lord, which I respectfully place before your lordships. And this is in sync with, my lord, my submission that except denatured spirit, every other sect of alcohol would be covered by entry. That, my lord, in my respectful submission, that should be an answer, my lord, to the question of whether, my lord, the fact, my lord, that in para 74 of.
You have got an answer to it, because even if, we accept what, suppose what the solicitor argued, that
Yes.
Tikaramji is really wrong in constricting the scope
Yes.
of industry.
Yes.
And therefore, industry would also cover raw materials.
Correct.
Your argument really is that if it falls within entry 8,
Yes.
because entry 8 says intoxicating liquor, that is to say
That is to
production,
say.
and therefore every stage of production
yes.
leading up to
Yes.
to intoxicating liquor is covered by entry 8.
Then I don't have to go to entry 22.
Then entry 52, once it
Yes.
specifically
Yes.
falls in entry 8,
Yes.
then a declaration under 52
Yes.
will not really affect.
Will not.
That's the point.
It's a question of, my lord, lack of legislative competence on the part of the parliament, my lord, to under entry 52 to touch any subject which is comprehensively covered by entry 8 of list 2. My lord. This is my respect.
For 2016, they set it right. Parliament, that's how Parliament.
2016, my lord, apparently they must have set it right and then gave it retrospective
Thank
effect.
you, Mr. Thank you. Anything else that we have
My
lost?
lord, except that, my lord, the question of revelation by forbearance and, my lord, reference, my lord, to the judgment in forum, my lord, for the purpose of repugnance. In my respectful submission, my lord, para 132 of the judgment in forum, which has been, my lord, copiously extracted in the learned solicitor's submissions. My lord, it dealt with this aspect. Lordships formulated the 3 tests. In fact, there is a conspect of all earlier judgments on the point on question of repugnance. And then your lordship said, there are 3 tests. Then your lordship said 1, 2, 3. My lord, I am not taking your lordship's time, my lord, to go through it again. But in every one of the tests, the key words that your lordships have used is text and context. How do you really assess, my lord, repugnance unless there is an actual text of the legislation there? My lord, I'll try to answer, my lord, the learned solicitor's submission that the legislation is the IDR Act. That's a different matter. But for the purpose of repugnance, when there are already, my lord, regulations of the state in place, and you want to take it away, my lord, I respectfully submit I am not regulating it. The center says under 18G I have the power to regulate it. I am not regulating it. Why am I not regulating it? I am forbearing from bringing about a legislation. Where is the question of repugnance in that? Lord, 18.1 speaks about expediency to be considered, assessed, and then acted upon by the center. Nobody has a case, my lord, that the center would step in there. That's not the case at all. Question is, unless there is a regulatory mechanism put in place, my lord, even in relation to an action taken under 18G. The question of, my lord, the regulative or what the learned solicitor calls as regulation by forbearance really does not come in. That does not answer, my lord, any test which your lordships have over the years and which is, my lord, which is completely, my lord, in place and which has been reproduced, my lord. There is a conspectus in forum. All the three tests contemplate either, my lord, a head-on collision, as your lordships call it, or, my lord, the question of compliance with one, disabling compliance with the other. Or what your lordship said, suppose there is a scheme in place, do you encroach into it by another legislation? That is where, my lord, the question of repugnance comes in. But for all this, my lord, there must be something in place. Forbearance, my lord, does not bring about a scheme. Therefore, in respect of that, my lord, I would respectfully submit that doctrine of forbearance, regulation by forbearance, really may not apply in the case, in this case at all. But I would respectfully submit, my lord, the question of, my lord, the jurisdiction getting transformed to or transferred, my lord, to the center should arise at the stage of removal or clearance, my lord, of the extra-neutral alcohol. This is what has been, my lord, put in place in para 23 of Hyderabad distilleries, my lord, in my respectful submission. So succinct, Bihar distilleries. So succinctly, my lord, in Bihar distilleries, paragraph 23. My lord, VAM Organics also, my lord, said the same thing. In fact, those two judgments are in 97-2 SEC, one after the other, my lord, back to back. Significantly, my lord, the High Court judgment in VAM Organics, which is confirmed by this Honorable Court, is by Justice Jeevan Reddy, who is the author, my lord, of Bihar distilleries. I'm saying, my lord, para 23 gives a complete answer, my lord, to the how to regulate it. Regulate it at a stage when extra-neutral alcohol is cleared for the purpose of industrial use. Beyond that, yes. But even then, my lord, what Bihar distillery says is this: regulation by the state for the purpose of preventing and misuse of the ENA, misuse of the denatured spirit, so that it doesn't make its way, my lord, to the circuit of potable alcohol or alcohol which is meant for human consumption. We have a right, my lord, to charge a regulatory fee. The states have a right to charge a regulatory fee. On manufacture, my lord, which is a tax, excise duty covered by entry 84 of list 1. Lord, I would most humbly submit, your lordships would have been taken through para 23 of Bihar distilleries. I would most humbly submit that if your lordships are pleased to affirm that, it would solve any problem that arises out of this. There is no dual control, my lord. It's a question of control up to the stage of clearance by the state, and beyond that, my lord, by the center, if it's for the purpose of industrial alcohol. Every aspect of this movement is completely covered by Bihar distilleries, is my respectful submission, my lord. My lord, I would respectfully submit, my lord, therefore, synthetics and chemicals, my lord, your lordships may reconsider whether.
Thanks, sir.
Grateful to you, lordship.
2-3 minutes. I'll just take this. Before this case, that the union and center never been on a loggerheads. The union has always been making a statement on the state side. So the harmonious operation has prevailed all this while. And if we see that.
Still not on loggerheads. The constitutional interpretation.
No, it's only on the, what I meant was only on this.
Which state are you appearing for?
No, state of Maharashtra. And we can't be. Well,
Prompt to respond.
In any case, Balbir Singh can never be.
Well, certainly I can't be. I certainly can't be. But it's only on the law and the constitution. Yes. So where that red line to be drawn is, and when the baton is to be handed over by the state, it's a relay race in my respectful submission. That till the time entry 8, which is the industrial, which is the alcoholic liquor, is carried out, and till the stage of denaturing, the control till today, which has not been disturbed, remains with the state. Today, the distilleries which are operating, the state authorities prescribe forms, documents, and the processes to be carried out, including the charging of excise duty and finally handing over the product to the bottlers or to the final distributors. It's only at the denaturing stage the product, if ANA is cleared, then it goes to the denaturing industry, and at that stage, the union's control starts. Pre that, the line is very clear. And if we see, this in the light of not only entry 8, but entry 24 and entry 52 of list 1, and if I may try and see the sense of Tikaram, Tikaram talks of the industries in schedule. Only 18G talks of articles and talks of distribution and supply. Rest of the other act talks of the industries which are given, and industries can have multiple products. And one of the objects, if we see, of this act is control by the union in public interest. And if we look at the scheme of that act, is one of the scheme is to have a control that what is the requirement of a country in respect to a particular product in a particular industry, what is the employment, what is the capital. When these all statistics are also collected through a different committees or which are formed over in different regions in the country, one of the objectives is that in one particular industry, what is the country's requirement and what is the country's production which is there. Tika Ramji seems to be in line with that, to say that when we talk of industry and why we should not look at the raw material is because raw material potentially can belong to a different industry. Let's say somebody say that the garment industry to be seen, whereas the fabric industry may be different. So if we look at the industrial control of garment industry is to be taken, may not necessarily be the fabric industry to be taken. India need how many garments in a year, how many jobs to be created, how much capital to be requirement in a one industry may not be there. So Tikaram in that sense has seen that. If we see or contrast this with the requirement of 18G is a fair price and fair distribution of a particular article for supply and distribution in public interest is to be seen. If we see this in that particular light and the control on a product or an article to be seen, although it constitutes a part of industry, in my respectful submission, and especially in light of entry 8, which is that is to say, and all aspects of right from the beginning of manufacture and final supply, transportation, even including a purchase which has been there, that has been given to the state in my respectful submission. And if we see Bihar distilleries, that makes it very clear that in this sense, if we harmonize two laws, looking at entry 8, and even if we pitch it at the level that how do we resolve a conflict of entry 24, although the first submission is the entry 8 is a carve out of entry 24. Even if we stop at that and we compare entry 24 with entry 52, then we have to have two segments in the 1951 Act. One act is an industrial level, which is to be seen, which is Tikaram when say production and manufacture. And second is at 18G, when till the time it has not been, there is no delegated legislation, there is no notification which has been there. So looking at this, I don't want to go in any other area. If you look at it, I've been informed, and the industrial association is there, 95% of industries today are operating, which are the industries which are carrying out the process of making IMFL products and denaturing also. So in a composite industry which is operating today, distilleries which are operating in this sense, can it be said that the entire, whether it's starting from a molasses or from the grain stage, the control should go to the state, to union, and not to the state? Which, in my respectful submission, is entry 8 is going to be redundant. But that seems to be the very purpose. Comparing with one industry which is not doing denaturing, finally clearing ANA or IMFL, in that case, that industry certainly will not be within the domain of union or the legislative competence of union. Handing that over to say that the denaturing to be carried out in those sense if you look at the harmonious construction is, as my lords have pointed out, and I see that at what stage, a clearance makes it very clear that up to a certain point, the state is carrying on, the baton is handed over. The moment this goes into a denaturing product which is being carried out. That, in my respectful submission, was that's the way of looking at this. Grateful.
Obliged, Your Lordship. Only one line, my lord. I did not. I did not address Your Lordship because I concluded, my lord, later only. Just pointing out on the question of the term industry, my note is 2G, Roman 2G. Kindly, my lord.
Just one.
On raw material, whether it should include within the term industry or not. But since, my lord, I stopped at
2G.
Roman 2, capital G. It was filed earlier, my lord, but since I stopped at, my lord, occupying field question, I did not, my lord, take your lordship. This may kindly be, my lord, treated as
only lordship, only one last thing.
By thanking all of you for your very erudite argument.
I appear for UT of Puducherry,
which has confounded generations of judges and lawyers. And
Lordship, sir.
thank you very much for your.
Grateful.
One last.
I have a question.
Somebody wants to argue.
Well, Lordship, just permit me last thing as a matter of fact only. So far as excise duty is concerned, because that is not what your Lordships are considering, no state has ever charged excise duty on extra neutral alcohol. That has been the position because that's entry is different. That talk about alcohol liquor for human consumption. That is not intoxicating liquor. So no industry, no state has ever charged excise duty. That's a factual situation that Lordship will consider.
Kindly, my lord, take care of, if they're indirectly, they may not get any relief in
because
GST regime. Nobody
dealing with the
argued
GST.
that. That's the intention of the industry.
Today.
If I may just have a word, finally, I'm looking at the watch,
Yes, my lord.
which is facing us, but behind you. This intoxicating liquor argument going on over so many days, and today we've had a very long day. Are we concluding so that everyone can go and have a happy hour?
Lawyers maybe, but we don't know about the judges honestly, and they have a
My lord,
happy hour.
my lord, I appear for UT of Puducherry, my lord. Our written submission is on record, 1L, my lord. We adopt the arguments of the learned seniors.
Grateful to your lord.
Grateful, fellows.
Lordship, in the last hearing, all the both IO and along with SP.
Well, to just have a look at the last order sheet. In fact, all these authorities have been called because they were stating that the diary is incomplete. This was the reason.
Yes. Our diary complete है. IO साहब कहाँ हैं? आइए आप IO साहब आप आइए. आप तो बैठिए SP साहब. बैठिए. आप तो सिर्फ ये देखिए कि आपके IO लोग कितने efficiently काम करते हैं. आपको तो सिर्फ इसलिए बुलाया है. और कोई आपको तकलीफ देने का मंशा नहीं है. हाँ, डायरी कंप्लीट है. क्यों नहीं भेजी थी पिछली बार कंप्लीट डायरी? आपने पहली बार इन्वेस्टिगेशन किया था कि दूसरी बार में आपका इन्वेस्टिगेशन है? दूसरी बार में. चलिए, तो पहली बार वालों से बात कर लें. वो कहाँ पीछे चुपके क्यों खड़े हैं SP साहब के? आइए आगे आइए ना. पहली बार आप IO थे क्या? शुभ नाम है? गर्दन झुकाने से शर्म दिखाई नहीं देती है वकील. ठीक है, जगन्नाथ नाम है आपका. आप अपने नाम को बिल्कुल भी सार्थक नहीं करना चाहते. कितने कैमरे थे वहां पर? मौका मुआयने पर कितने कैमरे थे जी? कितने का फुटेज सीज किया था आपने?
2 का निकाली सर
जी?
2 का.
कितना? और जोर से बोलिए. इतनी
2 कैमरे का.
तो ऐसा क्यों किया था आपने? क्योंकि आपके पास हम SP साहब से पूछेंगे. आपको ये जो आपके सितारे लगे हुए हैं ना, कितने 2-2 सितारे लगे हुए हैं आपके, आपके खिलाफ ये लिखाना पड़ेगा कि आपको इन्वेस्टिगेशन करना नहीं आता, आपको आगे से किसी भी केस का इन्वेस्टिगेशन करने से रोका जाए और आपको लाइन हाजिर करके डेस्क ड्यूटी आवक जावक क्लर्क बना दिया जाए थाने में या वो लाइन में। जब 9 कैमरे थे तो आपने 2 क्यों सीज किए थे? पहला सवाल, अभी तो पहला सवाल है। बताइए, उत्तर दीजिए। शर्म नजरों से होती है, गर्दन झुकाने से नहीं होती है। सुन रहे हैं एसपी साहब आप? ये आपके अधिकारियों की एफिशिएंसी लेवल है ये, और ये उनकी अपराध में संलिप्तता का इंडिकेशन है। इनको इतने बेसिक चीज नहीं मालूम है। किस पोस्ट पर हैं आप? ये 2 सितारे क्या इंडिकेट करते हैं? मिस्टर जगन्नाथ, आई एम आस्किंग यू, नोबडी एल्स विल रिप्लाई ऑन योर बिहाफ। ये 2 सितारे क्या हैं? किस पद पर हैं आप? हैं? उप निरीक्षक। कितने साल की नौकरी हो गई आपकी? जी 36 साल में आपको ये नहीं मालूम कि इन्वेस्टिगेशन कैसे किया जाता है? दूसरा सवाल, हमें वकील साहब ने पिछली बार ये बहस करी कि जो गड्ढे वगैरह उस कमरे के बिखरे हुए थे वो आप लोग सुसाइड नोट ढूंढ रहे थे इसलिए बिखर गए। जी जी जी। तो उसके पहले आपने सीन ऑफ क्राइम को डिस्टर्ब किए बगैर फोटोग्राफ्स लिए थे? जी आप, हाउ कैन यू डिस्टर्ब सीन ऑफ क्राइम विदाउट टेकिंग फोटोग्राफ और मेकिंग वीडियोग्राफी? लिखते जाइए, एक एक सवाल लिखते जाइए इनका। लिखिए, दिस कोर्ट आज श्री जगन्नाथ, क्या नाम है पूरा? जगन्नाथ 11 नहीं समझ में आ रहा, जोर से बोलिए, माइक जोर से बोलें। माइक पे एक जगन्नाथ 11 सर 11 earlier IO of the case. Question number 1. Shri Gyarasiya is asked that when, as to how many cameras were available at the scene of crime. Question mark. Answer likhiye. Shri Gyarasiya submits there were 9 cameras on the scene of crime. At the scene of crime. Next. Question. Shri Gyarasiya is asked as to how many CCTV camera footages were seized by him. Next question mark. Answer. Shri Gyarasiya submits that footage from only 2 cameras was seized. नहीं गलती हो उत्तर लिखाने में तो बता दीजिएगा, क्योंकि ये आपके लिए बहुत लंबी दूरी तक जाएगा। नेक्स्ट थर्ड क्वेश्चन लिखिएगा। श्री Gyarasiya is asked that Shri Anil Khare, learned senior advocate, on the last date argued that scene of crime was disturbed and the heap of mattresses, etc., were found in disturbed position because IO had searched for the suicide note below those mattresses.
अपने आउट ऑफ द बॉक्स बिजनेस आइडिया को आउट ऑफ द वर्ल्ड स्टार्टअप बनाओ। पारुल यूनिवर्सिटी आ जाओ। पारुल यूनिवर्सिटी वडोदरा, गुजरात।
Mattresses and the mattresses and pillows which were lying on the bed where allegedly incident took place. Full stop. Shri Gyarasiya is asked as to whether he had videographed the scene of crime before searching for the suicide note. Question mark. Answer. Shri Gyarasiya submits. बताइए, सवाल मैं हिंदी में समझाता हूं। मैंने आपसे सवाल ये पूछा है, ऊपर ये भी लिख दीजिएगा। Shri Gyarasiya is asked questions in Hindi and in presence of the learned counsel for the parties and the learned SP Narsingpur. Questions and answers are being translated in English and recorded in the order sheet. सवाल ये है कि आपने सीन ऑफ क्राइम को डिस्टर्ब करने के पहले फोटोग्राफी या वीडियोग्राफी कराई थी? जी बाद में देखिए, श्री ग्यारसिया admits that he had not carried out any videography or photography before disturbing the scene of crime. Full stop. He answers that he submits that he had carried out photography after disturbing the scene of crime. ठीक है एसपी साहब, क्या समझ में आया आपको इससे?
सर पहले करानी चाहिए थी।
तो क्यों नहीं कराई? आपका क्या सुपरविजन है? आपका थानों के ऊपर क्या सुपरविजन है? और इन्वेस्टिगेशन के ऊपर क्या पकड़ है आपकी? वो मैं सरकारी वकील साहब को बोल रहा था, शायद आप बैठे थे। 13 या 14 तारीख के इंडियन एक्सप्रेस में पढ़िएगा, पूना की पुलिस कमिश्नर ने आर्टिकल लिखा है दैट हाउ पुलिस फंक्शन, सेंट्रल पेज पर है बिल्कुल, 4 कॉलम का आर्टिकल। मैं उसको बोलना नहीं चाहता हूं यहाँ पर, आप आर्टिकल पढ़ लीजिएगा। एंड योर ओन पुलिस ऑफिसर who was on deputation to central government on various sensitive posts has mentioned that how police functions. क्या पकड़ है आपकी इनके ऊपर? बैठिए जगन्नाथ जी। हाँ, आपकी केस डायरी है पूरी? क्या स्टेटमेंट रिकॉर्ड किया आपने डॉक्टर का, बताइएगा, जिसने पोस्टमार्टम किया है? पीछे मत देखिए। तो क्यों नहीं लेकर आए आप? आपको लेकर खड़े होना चाहिए था। नेक्स्ट लिखिएगा, प्रेजेंट आईओ श्री, क्या शुभ नाम है आपका? कौशल सिंह। कौशल सिंह जी इज आस्क्ड, दीजिए वो स्टेटमेंट दीजिए डॉक्टर का, और थूक मत लगाइएगा कागज के ऊपर, वहां लगा हुआ है।
There with my application also.
हाँ ठीक है, पेज नंबर
259 से
59
query has been raised, sir.
जी 259
259, sir. And the answer is contained at page 260.
पेज नंबर 260
259 पे सवाल पूछा गया है
जी। किससे पूछा गया है सवाल?
ये फ्रॉम बोथ द डॉक्टर्स।
जिस डॉक्टर ने काटा, जिसके इनिशियल है,
दोनों से पूछा गया, दोनों को लेटर लिखा है।
हाँ, फिर
उनके जवाब है,
क्या जवाब है? पढ़िए।
एट पेज 260।
हाँ पढ़िए
सर, पहले तो क्वेश्चंस पढ़ देता हूँ।
हाँ पढ़िए।
मृतिका के पैर में जो चोट आई है वह कैसे, किस चीज की है? क्या इस चोट से छायाचित्र में दर्शित बेडशीट गीली हो सकती है? मृतिका को हायोड बोन में अस्थि भंग होना पाया गया है। क्या मृतिका ने स्वयं को फांसी लगाए जाने के उक्त हड्डी के अस्थि भंग हो सकता है, या अन्य?
पहला और तीसरा सवाल का जवाब मुझे बता दीजिए
सर, ये नेक्स्ट पेज पे आप देख लें, सारे जवाब।
तीसरे
सर, पहले का जवाब चाहिए आपको। मृतिका को राइट टो पर डीप एब्रेशन, गहरी खरोंच पाई गई थी, जो कि किसी हार्ट एंड ब्लड ऑब्जेक्ट से आना संभव प्रतीत होता है। डीप एब्रेशन से 6-7 मिनट तक ब्लीडिंग होना संभव है, तथा अब बेडशीट गीली होना संभव है। तो पढ़ दीजिए आप, आपकी राइटिंग ज्यादा क्लियर होगी आपको, पढ़ दीजिए। आप पढ़ रहे हैं?
बेडशीट का अवलोकन पीएम के साथ द्वारा नहीं किया गया,
नहीं किया,
ये इम्पोर्टेंट है।
जी।
ठीक है, ये हार्ड एंड ब्लंट ऑब्जेक्ट, मैं आईओ साहब आपसे पूछ रहा हूँ, ये हार्ड एंड ब्लंट ऑब्जेक्ट वकील साहब ने बहस की थी कि कुर्सी है प्लास्टिक की जो लेकर वो भागी थी कमरे के अंदर, आपने प्रस्तुत की थी डॉक्टर को कि इस कुर्सी से ये चोट आना संभव है? क्योंकि ये वकील साहब की बहस है, मेरी ओर से कुछ भी नहीं है, जोड़ है ना घटाव है। उसमें उन्होंने कहा कि ये कुर्सी उसने जब पैर मारा होगा लटकने के बाद उसका पैर कटक गया।
मेरी बहस सर पूरी उस पर थी, मेडिकल लीगल।
हाँ, अरे मैं आई एम नॉट Right, sir. Let me be very honest and clear. I have no business and I have no authority to say. I can deal with your arguments. I have to comment on your arguments. I'm only pointing out to him that this was the argument and whether that chair was produced, whether injury to the toe could have been produced, could have been sustained because of that chair. आपसे पूछ रहा हूँ आईओ साहब।
नहीं पेश किए थे।
क्यों नहीं पेश की थी? लिखिएगा। आईओ श्री कौशल सिंह, यही नाम है ना आपका?
जी सर।
Is asked that when he had given a query report, when he had sought a query from Dr. Pranav Sen and Dr. Rashi Rai of Government Hospital Narsinghpur on 26/3/2022, then whether he had produced the chair, plastic chair, allegedly contact with which caused injury to the right toe, as has been answered by the concerned doctors, as is available on in reply to the query report. Shri Kaushal Singh, ये question mark answer. Kaushal Singh submits that he had not produced said chair to ascertain whether injury in the toe in the form of deep abrasion, which was seen by the doctors at the time of postmortem, was sorry. Whether by in to the concerned doctor. अच्छा, आपके वो कहाँ जगन्नाथ जी कहाँ हैं? उनको भी बुलाते जाइए, चलते रहेंगे, ये कर लेना। ये बेडशीट क्यों नहीं प्रोड्यूस की थी आपने? जगन्नाथ जी को आगे बुला लीजिए।